So good morning. I'm looking forward to a lively conversation from our talks backstage. I'm Matt Thompson. I'm the deputy editor of theatlantic.com, and I have with me a distinguished panel. To my far right is Adam Foss, who's an assistant district attorney for the Suffolk County Attorney's Office in Massachusetts, working primarily with juveniles. Nancy Gertner, who was a judge at the outset as the carceral state began to rise in the 90s and has become a lecturer at Harvard Law School, and Cyrus Vance, the district attorney for New York County, the top district attorney in Manhattan. Both of our prosecutors actually come to us with an interesting history. Both, I believe, were defenders at one point. Briefly for Adam. So I'm just going to ask, what drew you to the dark side? I'll start with you, Adam.
Not too loaded a question.
Yes, nice, easy one to start off with. I wanted to be a defender for all the reasons that we're sort of sitting here today, the issues that we're talking about today. I knew that jail wasn't working. I knew that the people that were in there looked a lot like me, and I thought that the way that I was going to help that situation was to become a defender. And I learned two things while having those experiences working for a defense attorney all through law school and being a certified defender in law school as a student. Those two things were that, one, you have the least amount of power in the courtroom, and the prosecutor sort of has the most. And instead of asking for things all the time, I wanted to be able to tell people things.
Try judging.
Yeah. So that was the one thing I learned. And then the second was I wasn't really fixing any of the ills that brought my clients into the system by trying to absolve them of guilt. And so I really wanted to help those individuals make sure that they weren't coming back to court, not just on that one individual case, but in cases that came along in their path.
Yeah. So I think this is what we'd expect. The prosecutors, Cyrus, I believe you said the prosecutors are the stewards of the integrity of the system. You have recently overseen, co-chaired the New York State Permanent Commission on Sentencing and made a number of recommendations for how sentencing should be changed. And implicit in those recommendations is, I think, an idea of where sentencing power should accrue within the system. So I'm curious to hear, where do you think the power that now accrues to prosecutors should be?
Well, it accrues to prosecutors differently in different jurisdictions and different than the federal system. So New York State sentencing laws are not like Washington State sentencing laws. That said, the powers of the prosecutor, I think, really rest principally in discretion. Whether a prosecutor decides that she or he is going to charge this crime versus another, and whether that prosecutor decides a charge shouldn't be brought or how it should be disposed of. But where I think sentencing should land is I'm very comfortable with having judges have the power, broad latitude, and broad ranges. And in New York State, we actually have, I think, among the widest sentencing ranges in the country for certain offenses. What are called nonviolent offenses, judges have the power to sentence someone from 1 year to 25 years in certain cases. And I'm very comfortable with that because I think it's our job to advocate for the result that we want. It's the defense lawyer's job, and I was a defense lawyer for 20 years. I completely understand the importance of their work. They have to advocate for their client. And ultimately, the judge has to decide. And as I was talking about Nancy outside, it rests on the judge's shoulders at the end of the day. And so they take the weight of the decision because they have to make it in the end.
Yeah. So Nancy, I'll point the question to you. As it stands, we have two defenders who become prosecutors. We have many folks who would agree that prosecutors have a significant role in determining the outcome of cases for defendants' lives. As a former judge, where do you see the balance of power in the courtroom, and where should it be?
Well, I was in the federal system where the balance of power is overwhelmingly in favor of the prosecutor. The prosecutor had the ability, to offer someone 6 months if you plead guilty and 20 years if you go to trial. It was essentially a system of pleas. I mean, we're at 97% pleas. I was supposed to be there. There was a moment when I leaned over and would say to a defendant, has anyone coerced you into pleading guilty? And the person said, no, no one's coerced me. And I knew that it was a kabuki ritual, right? Of course he was coerced. Of course he was coerced. Hanging in the balance was an extraordinary mandatory minimum. So that the source of power is overwhelmingly, mandatory minimums bring power to prosecutors. And then when someone gets sentenced to a mandatory minimum, I was a potted plant. You know, I was the last step of doing what was the obvious. But I love the notion of judicial discretion. One of the problems about having been around for a while is that we see swings. And discretion is, as you know, is not a sentencing policy. It tells you where the location of sentencing policy should be, but that's not a policy. I want people to talk about some of the things that this conference is talking about, which is, evidence-based programs. What should we do with addicts? What should we do with kids most of the kids I sentenced were kicked out of school in the 10th and 11th grade. In other words, it's great to give me discretion when I was a judge, but I want guidance about how to exercise that discretion, not just guidance about numbers, but guidance about real, meaningful programs.
I want to step back for a second, reading the mood of the room, I think we've heard broad consensus or agreement from all the speakers this morning that we may have overreached as a country in sentencing, in the length of sentences and the nature of some of the sentences, in not paying enough attention to potential alternatives and what have you. But there's a sense that I think lingers over this whole conversation, that the conversation itself is quite fragile. What happens if crime goes back up? How does this conversation change? So I would start with you.
Let me give you an example of a current case in New York. And this is public because the individual is in court. We had an individual who has now been indicted for killing a police officer several weeks ago in New York City. That individual had a significant drug record and had some other conduct that ultimately wasn't charged but was relevant. While out on a diversion program, he skips, and he, while out, is alleged in a process of a fight with other folks to end up killing a police officer. So there's an example of you obviously want to support diversion, and diversion can be incredibly productive, but if it doesn't work out, and if the judge doesn't see in the crystal ball what's going to happen 5 years from now, and something terrible happens, yes, to answer your question, things can snap back very quickly, which is why I think, following Nancy's suggestion, we really need to be evidence-based. We need to have risk assessments when we deal with individuals in sentencing. We have to have assessments of the efficacy of the programs that we send people to, and have really a good sense that the dollars we're investing are good dollars. And in my view, from my perspective, I want to spend my law enforcement dollars for no more days in prison that are absolutely necessary. I want that to be the lowest number it can be in order to get the maximum amount of safety that we can achieve, as well as fairness. But a serious case can flip community sentiment overnight.
I mean, you had asked me before we came out here about Massachusetts, and Massachusetts has this great progressive reputation. The Willie Horton case from, 2-3 decades ago transformed Massachusetts sentencing. And so, in fact, we were regressive on numbers of areas. It's a funny kind of conversation because you'll say diversion, may not have worked in this situation. We'll look again at diversion. Of course, imprisonment never worked. And the response to imprisonment was always, well, you killed a couple let's increase the sentences. And all that happened was we had higher and higher sentences, with the same, even worse efficacy than we would have for these kinds of programs. But the public has to know that there are bound to be mistakes. There are mistakes in either end. There were a mistake in over-incarceration. There was a mistake in, releases. There are going to be mistakes on either end, and the issue is sort of risk assessment. The issue is risk assessment and what is the more efficacious in stopping crime.
And if I'm sorry, go ahead, Adam.
And to pick up on Nancy's point, it's the great irony of sort of being a progressive person in these roles, because you're looked at with sort of the side eye, like you're crazy, the things that you're suggesting are nuts and super risky. The irony is we know what happens when you send people to jail. It's bad for public safety. And so when you have these one-offs, the Willie Hortons, the Dominic Sinellis, you can't just close down shop and stop trying, because the alternative is just sending them back to a place that we know is bad for public safety. You have to take that risk and get the benefit of all of those cases that do succeed. Sure, there are going to be costs, and we have to immunize the public to the fact that there are going to be those costs. We have plane crashes, but people get on planes every day because they have to. There's going to be that one-off person that does something crazy. It doesn't mean you stop flying.
Adam, I was curious from your perspective. So working in the juvenile division in Suffolk County, you co-founded a program called Roxbury Choice. You've been doing a lot of work over the years to try to find alternatives to prison for kids in particular. What does that work look like? How do you shift someone in a different direction? What does that look like in practice?
So I just want to back up a little bit, because we spent a lot of conversation talking about police and then prison. And there's so many other flashpoints in the system before we even get there. So a lot of the work that I do has very little to do with jail. It's actually on the front end. And that just comes with an awareness that the new scarlet letter out here is G. It's just, you wear that guilty for the rest of your life. Jail ends, court ends, but that record that follows you around is the real problem, the thing that's driving this whole system. And so when you talk about sort of how do we reform this, you got to take it from the very beginning. Look at this case. Is the result of this case, the resulting conviction I'm going to get, is that going to lead to a better outcome in public safety, or is there something I can do at that point before this person gets a criminal record to divert them into a program to help them from causing another problem to begin with? Talk about everything funnels for some reason to public safety, education. I run a reading program in Dorchester for kindergartners and first graders. Is that me being a prosecutor? I think so, because there is a direct correlation between the cognitive gaps between suburban kids and urban kids at the time they reach the first grade and their projection in the criminal justice system. We have to talk about probation. A conversation we often leave out of this conversation is probation. There are people, mass incarceration is often driven by people who are waiting or are detained or are violated after a probation violation hearing. And we have to understand what that is. Probation is a service that people pay for. It is the only service that if you pay for it and you don't get the service that you're getting, you go to jail. We need to talk about that. We set people up to fail. We make them pay to get services, and when they fail at what they're doing, we lock them up. And so we need to expand the conversation from just re-entry in prison and policing to all of the players along the way that play into and are complicit in this problem.
So speaking of all of these gates, and now, I see Nancy is smiling. Nancy, being a judge, right, having been a judge in your state, would say, Adam's one of the good guys. He's thinking about this problem the right way, right, as a prosecutor. Cyrus, there was an interesting study that you actually opened your books to the Vera Institute a couple years ago and said, come in and look at how race affects outcomes for defendants in our system. And part of what that report found was that race did, of course, affect those outcomes at different steps along the way, from whether cases were dismissed, from charge offers and sentence offers, to whether people were detained at arraignment. One of the things that was interesting to me, to sort of return to my first question, was that actually one of the factors in several of those cases that was more significant than race itself was counsel type, was the type of counsel that people had access to. We don't hear the word defenders much in this conversation, but how do we help people get a better defense?
You have to resource the defense function, and it should be not a last thought issue in who gets funded in the criminal justice system, but I think the legislature or the municipality has to fund the defense function. That's how the system works well. The courts and the bodies that look over licensing have to make sure that the lawyers who are practicing in these courts are actually up to speed. And I think that is sometimes lax. That doesn't get happened enough. But in the Vera report, Vera is a not-for-profit criminal justice think tank, bringing Vera in to analyze analyze bias in our system was a real help to us, and ultimately it led me, following the report, to focus our efforts on appropriate diversion, expanding diversion, particularly for young men and women, before they go downtown, to divert them before they have to go to the criminal justice system, and give them the opportunity to reset, to make smart judgments on diverting the ones who actually are arraigned and giving them an opportunity to get out of the system healthily, and also in New York City to change the practice of making arrests for summonses, which are essentially tickets, and having those processed criminally and push them into a civil summons part. So altogether, you're talking about 25 to 30,000 people who we hope will have a different route or alternative routes through the criminal justice system in a given year. And that's, Vera helped me see, this is how I think we can address issues of who comes into the criminal justice system at the bottom, because most people come in young,
right,
and you've got to do a good job when they come in young.
Well, what was helpful was because you're dealing with a system that didn't have the kind of mandatory minimums that the federal system has. On the federal side, you can give public defenders gigantic resources and it will make no difference, no material difference, rather, to the kind of situation I'm describing, because no fabulous counsel even will take the risks of going to trial when what hangs in the balance are these kinds of mandatory minimums. But it's also, the funding issue for defenders is very interesting. After I left the bench, I saw that the Massachusetts had a rule. The judges said that they were going to disfavor psychiatric reports at sentencing unless someone had a pre-existing psychiatric condition. Otherwise, it would be a disfavored expenditure. The black kids that came before me were seen as discipline problems when they were teenagers. Not a one of them was sent to a shrink. So that to some degree, that constricting of resources had basically a biased effect. And those are the kinds of things you have to analyze, you have to look at.
Right. And
they didn't speak the language of psychiatry. People spoke the language of discipline to them.
I think Adam would agree to me that we are capable now of looking at where individuals become criminally justice involved in their life. It could be that they go to a hospital for some injury. It could be that they are truant from school. We have to resource the system as it pertains to crime prevention as opposed to just crime prosecution. Right. And if we are able to use data and be more intelligent to know who is at risk and to reach out to that family or that woman if it's a domestic violence situation and we know she's been to the hospital 3 times in the last 6 months, if you had to choose between prosecuting someone for a robbery and preventing the robbery from occurring, you'd pick prevention. But we don't spend money on prevention like we should. And if we do, I think we'll get better outcomes.
Well, we thought that the only prevention was long sentences, that would deter. But of course, it does not at all. The people that I was sentencing expected to go to jail. Absolutely expected to go to jail.
And you add that on to what we know about the people who are in jails in the juvenile context, and even the people that are filling our jails and prisons are predominantly people between the ages of 18 and 24 years old. Their brains are developing in such a way that you can tell them you'll spend the next 50 years in prison. That means nothing to them. What matters to them is how I'm going to survive until tomorrow, and what are my friends doing. We need to stop acting like we are different silos, and we just get these people as they come to us. They go to the schools, they get disciplined at the schools, they get sent to the police department. The police department takes them to us. We give them to probation. Probation gives them to the jail. And we're all complicit in this. There is a problem. We are all complicit in the creation of the problem, and therefore we are all responsible in figuring out the solution to that problem. And from the prosecutor's side, that means learning more than where do I stand during a bail argument, how do I give a closing argument. It requires that we learn about adolescent brain development, about the history of race in this country and what it's done to black and brown people, about the effect of trauma on people and how that impacts crime. And so that when I'm in a courtroom, standing there, getting a police report, regardless of if I've been a prosecutor for a day or 10 years, I look at that police report and I see more than just the words on the page, but the individual that's on the other side of that aisle. And if I want to keep them from committing crime, using everything that we know that's already there in data and research, and applying that in developmentally appropriate ways so we avoid that person from ever coming back.
And that is crime fighting.
Right.
That's
right.
crime fighting.
Public safety issues, right. That's right.
I have many more questions that I want to ask you, but I'm also going to want to give any of you an opportunity to ask a question to our panel. Before I do, I want to talk for just 1 second about solutions. Nancy, you had proposed in an op-ed or mentioned a proposal last week in the Boston Globe that of the idea of a Marshall Plan for communities as one of the other forms of redress in the back end of this. What does that look like? What does that mean to you?
It was Mark Bauer and of the Sentencing Project, I have to give credit where credit is due, and David Cole, who came up with the idea. But the notion here is that you can't just do things going forward. There are programs we have to do going forward to deal with these issues. But we have really, there are consequences to the carceral state. And the consequences are communities that have been decimated by, as the New York Times described it, absent, a whole generation of men absent. There's an intergenerational problem. There's an educational problem. There's an economic problem. And I said, why don't we look at this the way we looked at the post-World War II period? That we have to now rebuild communities that have been decimated by mass incarceration. So it's not just going forward. It really is a rebuilding process. And what I said in that, too, is that it's really, we're at a very crucial moment and a very dangerous moment, because if we don't take advantage of this time, I really fear we can go backwards. And less punishment is not a policy, although that's fabulous. And likewise, discretion is not a criminal justice policy, although that's fabulous. What we have to do is rebuild. We have to talk about evidence-based practices. We have to think about how we got here in terms of what the causes of crime. And we, you know, that was sort of mocked a couple of years, you know, when I was a kid, you know, the root causes of crime was a sort of liberal mantra. But in fact, we actually do know much more about brain architecture, the impact of toxic stress on children. We do know much more. And if we focus on that, we can make some changes.
We need to do that by immunizing the public. And again, it's on all of us, but particularly the media. You don't see news cameras standing out of high schools being like, there wasn't a gun in this school today. You know, they only go there when there's a gun in the school. Right. Politicians and district attorneys and legislators' idea of safety is not the idea of safety of people in the community. And you need to get proximate to see that and stop using public safety as a shield to the real issues of what we're doing. And the media is playing a large portion. John Legend in his #FreeAmerica campaign is one of the people out there that is just bringing this conversation out and trying to immunize the public.
Don't blame the media too loud here.
I won't.
Adam, what questions do we have in the audience? Over here, I see a hand. Oh, right over here.
Yes, thank you. I'm Nikichi Taifa. I'm with the Open Society Foundation, and I also convene the Justice Roundtable. My question really is to Adam Foss. First of all, I'm very inspired by all the progressive things that you're doing in your prosecutorial office. My question is, given that there's structural and institutional racism that's embedded not only in police departments, but in prosecutorial offices and in court processes, how have you been able to navigate, you know, shall we say, those types of issues in the office in which you find yourself in?
You have a right to remain silent.
Yeah, God, man. I have the luxury of working in an office where there's a lot of autonomy and discretion, and I've been able to exercise that autonomy and discretion. And it wasn't easy early on, but after a while that I had taken these risks and given the people that sort of decide whether or not I have a job being able to give them nice stories about people that we had taken risks on and now they're thriving in the community just sort of built up enough capital to be able to continue doing the things that I do and saying the things that I'm saying today, I hope.
Thank you for that. A question over here.
Yes, good morning. My name is Susana Marino, and I'm here with Catholic Charities. But today I'm here as a mother of an incarcerated son who is currently in prison. And obviously, we can see that this is a national security problem that we're talking about. 2 million people in prison, 700,000 in parole, and about 7 million in probation, okay, the numbers add up, and it's more than just 2 million, like I just said. But we have a problem here of lack of accountability, in my opinion. And so what are we doing at the level of counties and different states? Since I understand that states have jurisdiction over federal matters, there are some states that are worse than others. For example, my son is in Florida, and he was direct file at 16, and he's 21, and he hasn't gotten over. And so if you don't pay your restitution, you're back in prison, and it's in, that kind of cycle.
So to focus on accountability first.
I'd like to focus on the accountability, the difference between the federal system and the state system. Now, I have a great respect for federal prosecutors, but they are not accountable like elected prosecutors are. And in each election cycle, the people of my community get to decide whether I'm doing a good job or not. And I think that makes for a healthier criminal justice system. When, as an elected individual, I have to go to communities to understand what they care about, to understand stories about their children who they feel should not be incarcerated or are for too long, and contrast that with the federal system where I think you have honest, diligent, talented prosecutors, but they're really not accountable except through the president and their boss, the U.S. attorney, who is appointed by the president. So that's not a criticism of the federal side, but I think it's a reflection that we actually do have accountability at least on every 4 years.
But there has to be, that actually can work in one of two directions, right? You can be accountable to a public that wants blood in this particular area. We used to kid around about how our criminal justice policy was determined by the crime du jour, which is whatever hits the newspapers, prosecutor feels he has to do something about. So you're accountable on the one hand, but you also need some independence from a mob. And arguably the federal system has that independence. But that's why that gets back really to the mandatory minimum discussion. You need a system in which different players balance each other. So that if a prosecutor comes to me with a charge that is ridiculous and I find out more about the case, I want to be able to say that charge may be appropriate in the case of a dealer of megatons, but not this kid. So that's where judicial discretion plays in sort of as an antidote to a prosecutor, but judges have to be accountable too for what they do. So I think that there's a balance there, but right now the system is skewed. I'm assuming that it's the war on drugs has skewed this completely. I used to sentence people. It was like a column of figures, and by the time I got to a number, I'd go, that cannot be. But there was no discretion to enable me to say, I can't sentence you to that.
The problem with the accountability piece with regard to elected prosecutors is that you're assuming that accountability applies to everyone and everybody has the ability to exercise that power, to be involved in the process of electing a prosecutor. But when you disenfranchise people, either through making them just inherently distrust the system and not want to get involved in voting for the prosecutor, people not being educated about what a prosecutor actually does and is capable of doing. And let's not forget to talk about the fact that people who are convicted of certain felonies are excluded from voting. You can get a very skewed picture of who the person that is being elected is representing.
Adam, Nancy, Cyrus, I think to bring our session, we have a very brief question.
Just really quickly. My name is George, organizationally independent, strategically, but I wanted to, there's a lot going on today that has been like using words that are finite or talking about constructs as if they're finite. And so we kind of touched on it where it's like, we'll say society. And society is assumed to be good, where we're not talking about the fact that it's this very society that has produced the product that is now just a symptom. It's not even what is actually the problem. When we talk about, prosecutors and that accountability, it's like we look at Hillary Clinton. She wasn't talking about banning the box until it was necessary for her to get elected or to run for president in this system. So it's like, again, you kind of touched on it, Adam, in looking at, well, so many people are disenfranchised from this system. So really when I say, how can I realistically expect the system, and we look at things like we use the word morality here a lot. Well, this is a country that didn't deem me morality in a moral sense simply because I was born black. So how can I realistically expect this system that has created all of these conditions to really be the system that fixes it?
Get in the game.
All right, so we're not going to be able to answer that question.